Okay, I think we're going to start. We are 3 minutes in. So thank you for joining OUTA's media conference. Today, I just want to introduce my colleagues, Advocate Stefanie Fick, on my left, Head of the OUTA Accountability Division and Executive Director at OUTA, Brendan Slade, Project Manager on Energy Matters at OUTA. They will be answering most of the questions. What we will do is take questions. You can raise questions either in the chat box or after Stefanie has read out our media statement. We will also take questions live from the audience in the Zoom room. And what you will find is that our comprehensive statement will be on the website at outa.co.za shortly into the session, as well as on that page you will find the affidavit which has been uploaded as well for our matter that Stefanie is going to read to you about now. We'll give you the input on. So Stefanie, thanks. Over to you.
Thank you, everybody, and welcome. So the organization Undoing Tax Abuse is bringing an urgent application against the government aimed at overturning the declaration of a national state of disaster over the electricity crisis. The application was lodged in the Pretoria High Court this morning. Our case is brought against 8 respondents. It is directed mainly at the first 5 respondents, who are the President, the head of the National Disaster Management Centre, the Minister for Cooperative Governance and Regional Affairs, and the Minister of Mineral Resources and Energy. The other respondents are cited as they are interested parties, but no relief is sought against them unless they oppose our review application. We are asking the court to review and set aside the declaration of the national state of disaster. We are also asking the court to immediately interdict the first 5 respondents from taking any further steps in terms of the state of disaster, pending Part B of our application, which aims to review the decision to declare state of disaster. Now, OUTA believes the decision to declare the disaster was irrational, arbitrary, and unlawful. The electricity crisis is not new, but was created by the government itself over many years through failures to implement plans or to hold people to account. Years of state capture, mismanagement, and a dysfunctional culture are not a rational justification for the declaration of a national state of disaster. The state of disaster grants extraordinary powers to the authorities to make far-reaching decisions without parliamentary oversight, which is a concern in the light of past extensive looting enabled by emergency procurement during the COVID-19 state of disaster. Even real-time auditing by the Auditor General of the COVID spending could not stop the looting of the COVID emergency funds. We are also concerned that if this national state of disaster is allowed to stand, it will open the floodgates for further such disasters to be declared in other sectors that suffered from similar dysfunction, management, and corruption. Declaring a national state of disaster will, in effect, become a tool for government to circumvent accountability and hide behind the excuse of a disaster to reach an apparent quick fix for problems that were years in the making. I have made the founding affidavit in OUTA's application explaining why we are opposed to the national state of disaster. These are some of the reasons. Firstly, the Disaster Management Act explicitly excludes processes which can be dealt with effectively in terms of existing national legislation. There are already legislation available to deal effectively with emergency electricity procurement. For example, the Electricity Regulation Act allows the Minister of Mineral Resources and Energy to enter into agreements for new generation capacity, including emergency supply of power. The National Energy Act allows the minister to acquire, maintain, monitor, and manage national strategic energy feedstocks and carriers, and to direct any state-owned entity to do this, including deciding the mechanism for paying for this. This act allows this minister to direct any SOE to invest in and maintain energy infrastructure. Then also the Public Finance Management Act provides for the use of funds in emergency situations, authorized by the Minister of Finance. Secondly, there is already an energy action plan in place. This was announced by the President in July of 2022, developed through extensive consultation and endorsed by energy experts as the best and fastest path to energy security. At the time, the President said that this plan was preferable to declaring a state of disaster. The National Energy Crisis Committee was established to oversee this plan, and its report last month lists achievements and does not mention any imminent national disaster. OUTA supports the Energy Action Plan, and we believe it is a feasible plan to take South Africa out of the electricity crisis. It is a clear plan and does not require a national state of disaster. What is required for government is to implement this plan. Thirdly, the national state of disaster is explained by concern over a possible total blackout. However, there is no evidence that a total blackout will occur. The Disaster Management Act does not make provision for a disaster to be declared on speculative future event, only on an existing event. Just a few weeks ago, on the 22nd of January, Eskom said in a media statement that even though the stages of load shedding had been high and over extended periods, there is no higher risk of blackout than normal. Fourthly, Eskom does not appear to have been consulted about the need for a state of disaster. It is extraordinary that Eskom would not be consulted. Just 2 days before the President announced the state of disaster, Eskom told Parliament that the best short-term solution was to find funds to run the diesel power generators and to relax some of the procurement requirements to speed up procurement. These actions do not require a state of disaster, and Eskom did not indicate a need for a state of disaster. Fifthly, we are concerned that the Minister of Mineral Resources and Energy will use the excuse of a state of disaster to justify an emergency contract with Car Powership. OUTA is currently involved in litigation to overturn the Car Powership generation licenses. A key point of dispute in that challenge is the exorbitant cost over a prolonged period of time for these projects. Number 6, we are concerned that procurement will be fast-tracked and hidden. Under a national state of disaster, fast-tracking of procurement is available to all departments. The COVID-19 national disaster showed how many authorities and businesses took advantage of such relaxation of rules and oversight, and how even real-time audits by the Auditor General could not prevent the widespread abuse. The reduction in oversight is an invitation to corruption. Lastly, there is no evidence that the state of disaster will help, and to date, there is no indication of what government intends to do that requires a state of disaster. To summarize, OUTA believes the electricity crisis, which South Africa has struggled with for more than 15 years, should not be addressed through the introduction of a national state of disaster. Recent history has shown us that a state of disaster will be used to abuse powers and enable large-scale looting and unaffordable contracts, but will not necessarily add any weight to resolving the electricity crisis. OUTA is bringing this application because we strongly believe that society must reject the government's attempts to grant itself extraordinary powers with reduced oversight when having to deal with a self-created energy crisis. Thank you, Wayne.
Thanks so much for that, Stefanie. So I guess now it's over to the journalists in the room. I don't see any questions in the chat box. So we'll look out for hands up. Any questions you want to pose to Stefanie or Brendan or myself? We'll take questions. Otherwise, you will be able to find the extensive input on this media release at the OUTA, on the OUTA website, in the newsroom. It'll all be there with the affidavits uploaded as well. I see your hand is up, Chris. So over to you.
Thanks, Wayne. Wayne, it seems like there's a groundswell of actions, legal actions coming from civil society. Can you indicate which other civil society organizations are taking legal action? And is there any coordination between civil society parties or any other parties taking, litigating in the way that you are doing? If you can just give us any indication, are you collaborating with or talking to other organizations in this regard, or is this a completely independent effort? Thank you.
Okay, I'll deflect to Stefanie if she wants to add, but from what we know, we took a decision after listening to the SONA speech on Thursday evening. We unpacked the detail thereof relating to the state of disaster. We got our attorneys to have a look at it over the weekend. Monday, we reconvened and started with our application after feeling that there was a very comprehensive need to address this matter. We have not been or seen any other activities of this nature other than a political party. I think it's the DA and the union, as in solidarity. We've seen that in the media. We haven't been in consultation or discussions with them at all, and neither have we been in consultation or discussion with any other civil society organization. So we don't know of others. I imagine there could be, but maybe Stefanie or Brendan, if you've seen anything else in this regard?
No, I think that is the sort of organizations we know of. May I just say that I think that the more the merrier in this case. I think the amount of attacks will show, not necessarily an indication, but will show that, we are in one mind that this is a bad idea. I think each and every organization has got their mandates, has got their idea of why they want to attack this declaration of a state of disaster, which will only help a court in coming to the correct decision. I imagine that if there is more than one application, that they will be consolidated because it's the same subject matter. But I really don't see this as necessarily a problem. In fact, I think it's an indication that people are really not happy with this declaration. Brendan, I don't know if you...
No, it's just good to see that a lot of other organizations and individuals out there are able or willing to speak up to this wrong that's unfolding in front of our eyes. And basically, we are pushing towards the same goal. It's very, from the arguments we've seen out there from both Solidarity and the DA, there's a big golden thread going through from all arguments that this is a superfluous thing, the declaration of a state of disaster, and there is already a legal framework that needs to be utilized in order to address the current crisis.
Thanks for that. I don't know, have we answered your question, Chris? I take it we have.
Perfect.
Thanks. I'm going to take a written question from Cliff Sheeker, and then I will come to you, Clyde and William. So Cliff asks from Jacaranda FM, what solutions is OUTA putting on the table to address the problem at hand? I think, Cliff, the short answer to that is that this issue is about the state of disaster. We are not specialists in providing solutions, but having said that, we do consult with our energy experts and input, and do provide input from time to time, and have done at various levels and in parliamentary space on the issues at hand. And as far as we can see, the state of disaster, or the plan that government has in place through NACOM, is being addressed, seems to be comprehensive, and it has its both short, mid-term, and long-term strategies. Our concerns here is that if we don't get into the long-term mindset of dealing with energy security, and this is updating the IRPs, the IEP, which is still needs to be promulgated and put in place, and so much other stuff in planning for our future requirements, we get stuck in this rut as we have been for some time. On top of that, solutions related to sabotage, related to corruption internally, these are matters that can be and should be dealt with and are adequate if they're implemented. As Barney says, it's all about implementation. And then obviously the IPP, signing them up as quickly as possible, as early as possible. What we have looked at extensively is the car power ships option as well, because it was a year ago that we filed our papers against NERSA for granting the generation license for a number of reasons. Firstly, they hadn't followed due process, i.e. the environmental impact assessments hadn't been granted, and that was a serious concern. But not only that, the long-term impact on the economy and how they arrived at that decision, there's a lack of transparency, and they're doing everything they can not to allow us to have that detail, which is why we're in court still, this a year later, trying to get that information. So I hope that answers your question, Cliff. I'm going to hand over to you, Clyde.
Thanks. Just a technical question. Given that the state of disaster has been declared, does that not trump any attempt to stop it in a court of law? I'm just wondering who holds the trump suit here, the criminal justice system, the courts of South Africa, or does a declaration of a state of disaster trump everything else, like it seems to trump the environmental laws, the procurement laws, etc.? So that would be my question. Thanks.
So I actually like that question. So you have the separation of powers. You have your legislative arm, and you have the judicial, the courts. Now, what we are talking about here is an administrative action. So you can always, you have a right to approach a court, and this is about reviewing this decision that they took in order to declare a state of disaster. So although a state of disaster, which is part of our problem, can create the situation where we are worried about car power, is that they will scupper over the environmental authorizations and so forth, trying to push through this contract. That is possible, but it does not trump oversight by a court of law. Obviously, a court will look at the facts and will make up their minds objectively, hearing both sides, but you have the right to approach a court in order to review this administrative action. It's a constitutional right that administrative action should be fair and reasonable.
So the court can, if they rule against it, deem it as rule against the state of disaster, in which case they can't proceed.
That's correct. And that's why we approach this A and B sort of scenario. So we first asking on an urgent basis that the court give us an interim interdict, so that although the declaration will sort of stand, is that the government can't then give out regulations and so on in the meantime, and while this case is being argued. So only afterwards, then either the declaration will fall away, or it will continue.
Great. Thanks, Clyde. Did that answer your question?
Yeah, I had a follow-up question as to whether the state of disaster would be held in abeyance while the court was giving its ruling, and you answered that before I could ask it. So I don't know if you were reading my mind, or maybe we can use Stalingrad tactics here and keep it in court for 2 years until we sort out our energy emergency ourselves, and keep the state of disaster disaster stuck in court, as it were. Wouldn't be
Yeah,
the
we
first time.
actually invited, we said that we bring this on an urgent basis in order to stop you from issuing regulations and so forth. But the review application doesn't have to take forever. That depends on how serious you think this decision needs to be decided in court. And I think we all know how long litigation can take if the government decides to filibuster and throw you with the fact that they can litigate with taxpayers' money. But in this instance, it will maybe show how serious they are about this problem.
Okay, William, I'll come to you now just to take a text question in the chat box from Tando Maeko from Business Day. When does OUTA expect the courts to hear its application, given the government is expected to gazette the state of disaster regulations soon?
So they have received the paper. So, I think on a collegial basis, they will know that this is now a matter before court because it's urgent. If I'm not mistaken, the papers say the 28th of February. So that is next week, in order to do this as urgent as possible, because we do not want government to issue any regulations. I think seeing that they haven't and have received and will hopefully receive this, this application as soon as possible, I believe that our papers are with the sheriff, so that it can be served on them, is that there will not be any regulations until at least the urgent application is finalized. I hope that makes sense.
Thank you. William.
Good afternoon. Let me just turn on my camera as well so we can all have a sense of camaraderie. Hi there. My question, I have two. Stefanie, my first one, I think you've started answering it there, but in the case of this mounting pile of applications against the state of disaster, with the track record of the government, isn't there a chance that they'll try to push through regulations before the court hears these applications? And if so, if that is possible, I'm not sure, are you making provision for a Part C to your application to review even more things that they might pass before you can interdict them? And then Wayne,
Well, applications, sorry.
sorry, Stefanie. Wayne, my question to you is just, what do you think the reasoning is behind President Ramaphosa declaring the state of disaster? We all understand the possibility for nefarious things, but surely it can't be a nefarious motivation to declare the state of disaster. But it seems to have come out of the blue. What, in your opinion, is the reason that he actually made this decision?
Yeah, I think that's why we are going to court, William. It doesn't make sense to us, given, as Stefanie said in the statement, the powers that they already have, the laws that are in their favor and on their side to deal with this. So we're not sure. I mean, obviously, we wouldn't say that it could only be for nefarious reasons. But what we do know is that nefarious reasons become an objective once these situations arise, which is a serious concern. Remember, recently, we have heard the Minister of Minerals and Energy Resources and Minerals and Energy, William Mantashe, making comments on the car power ships option, knowing that it's in court, and starting to make comments like, well, maybe a 10-year deal is better, but it will push the price of the cost up. Now, obviously, to make statements like that, there's been engagements. There have to have been engagements in the background with car power ships, potentially. It sounds like it. So already we started to become concerned around government's comments and statements in the media on alternatives, which we have a serious reservation about. So, not that it might be overt, but in the background, it doesn't seem to add up, and it doesn't make sense, and that's the reason why we are bringing the application. To you, Stefanie, on the other question from William.
I'll try. So let me start off with this Part C. So no, the application does not make provision for a Part C. I mean, in our discussions, it's open for anybody to attack not only the state of disaster, I mean, under that declaration, but also to attack on if they have the basis for each and every regulation that is issued or gazetted in future. I do believe I can't speak on behalf of government, and unfortunately, we've seen that sometimes we do not understand the actions taken by government. But I have to believe and I have to trust the process that because they know that this challenge is now in court, that they will run the risk that if they, despite the urgency that we allege, despite the fact that we want this heard, especially the interdict, heard urgently, for them to then go and in any case file regulations, I think will only come back to bite them. It will be egg on their face because you're talking about costs. I think it will be male fide on their side. So although I really cannot say, but if you have to press me for an answer, I don't think so. I really don't. I think they realize this is a crisis. Plus, may I just say, I mean, it's the 16th of February. This was done on the 9th and nothing yet. Now, except for the fact that it speaks to the intention, and I think it just makes it clear that although the president picked the biggest stage to announce the state of disaster, it really points, and not from a legal point of view, but more from an emotional point of view on, but why did he do that if not immediately we see regulations in order to solve this crisis and disaster, but be that as it may, I have to believe in the process and think that we won't we won't have that problem. But rest assured that if that problem comes up, we will be ready to take them to task for being underhanded tactics. I think that will just speak to them.
I think if I could add to that, Stefani, there are other organizations that have said they will wait for the regulations to see if they want to litigate. And yes, as Stefani says, we would possibly look at further legal action, and that's a separate matter we could bring separately if and when those regulations do come out, and if and when the interdict isn't applied, and if and when the Part B review is taking its time. So those options are always still available to us. And I imagine, Stefani, with the common thread of 3 cases, the judge or the judge president or the deputy judge president, depending where they're all laid, in which courts could co-join or bring these cases together and listen to all parties on the same day. That's been happening.
That sounds practical.
Yeah. Okay, Miriam, just state which media house you're from and go ahead with your question.
Thank you. It's Mariam Issa with EE Business Intelligence. This has kind of been answered, but I just wanted to be absolutely clear. While this case is with the court, is there any way the government can go ahead with the car power ship deal?
Let me go first. I mean, again, I want to say, you never know what government is going to do. So there is always a possibility. But I think by curtailing their ability to issue regulations, hopefully it also curtail that behind the scenes, quickly getting the environmental authorizations pushed through. That happened previously, because that's why they were in this appeal procedure, etc. And thank goodness for organizations like New Connection and Liz and her team that can attack the environmental authorizations. So, you can never say never, that I've learned, but I think having the spotlight now on the state of disaster, the fact that people are unhappy, plus that we've put back the spotlight on car power ships. Again, I can just say, I don't think so, but if it happens, I think we are ready this time. I think we've learned our lessons. We've learned that, there is a trust deficit, unfortunately, when it comes to certain dealings, and that, our eyes are open and our ears are on the ground, so that if we hear anything, it will definitely be a fight. But they need to be careful because we are busy with litigation. In terms of also reviewing nurses' decision, that they do face some, cough orders, and it shows their, really, again, I want to reiterate their mala fides. So although I can't really answer your question, I hope that helps, because I think we're ready. This round, we are all ready, with our eyes open. We are sleepy with our eyes open.
Thanks, Miriam. I hope that answers your question. And just to highlight the fact, if you didn't know, we are in court against nurse and car power ships on their decision. It's been for a year, and I can tell you this, they're doing everything they can not to provide us with the information of how they reached that decision, which tells you something. They really are dragging their feet, and it's been for several months now. Okay, Clyde, back to you.
Just a quick question. How do you intend going about countering what's obviously going to happen? You fighting against stopping one stage of load shedding in South Africa. Whose interests have you got in heart? You know, the car power ships are going to come in and save us a stage of load shedding, and now you're stopping that. So we've been driven to the so-called point of where I think one or other of the ministers has actually said, we have no choice anymore. We just have to do this. I know what the answers to that are in a sense, because this is, we've seen this developing, but how does OUTA and how do ordinary South Africans counter what many people, and I'm seeing now quite a lot of people in the energy space are saying, well, maybe, if they just come for 3 years or something, it'll all be cool. And maybe we do really need them now. What's the strategy there when your friend at the braai says to you, I believe you and your mate stopped us, gave us this extra stage of load shedding? Thanks.
So Clyde, I'll start with this and ask Stefanie to come in. We're not opposed to car power ships for the sake of being opposed to car power ships. We're opposed to the 20-year deal, generation license that was given at prices pre the Ukraine war, prices of gas. It is a lot more. We estimate closer to R500 billion over 20 years. Now, obviously, if government or car power ships comes to society with a deal or an option that is for 3 years, that can be installed within a short space of time, relative to other options that could also be installed in a short space of time, but which have a cheaper option for longer term, like renewables possibly, or whatever it is. So we'd be guided by our experts that we engage with and that we get input from on that. If a 3-year deal or a 5-year deal for that matter on car power ships came in and it made sense for the emergency and the costs were right and the contracts were clear and there was transparency, I don't think we would object to that, but we'd have to see that at the time. Right now, what they put on the table, which we're objecting to, is just not acceptable. You cannot lumber and encumber South African citizens for the next 20 years with a deal that will kill this country as far as we're concerned. And is fraught with smoke and mirrors and lack of transparency. I don't know if I've answered that question.
Yeah, all I can add is that if I am cornered at a braai, they will first listen to this sermon, is that we are taking on car power, or we're taking on nursing, because they gave car power a generation license without taking into account the economic fallout that's going to happen. It is just too expensive. It's like literally cutting your nose to spite your face. If we can use that money just for the diesel that Eskom needs, I think it will take care of maybe, I'm saying this tongue in cheek because I don't know factually if that's correct, but maybe will save us 2 stages of load shedding because they are able to run it. And if you then parallel with that, look at alternative power solutions, etc. Car power just seems not worthy. If you have to say that doesn't matter the environment, let's just get the ships in there. You're literally going to leave half the earth to our future if that is your thinking, and it's not going to solve your problem immediately. So it's really, I think people need to understand that although it's sold, and I think if the rhetoric out there keeps on saying the car power ship is your salvation, hopefully one can, say that it's not. It really is not. It's too expensive. And, if you want to say that a deal where the cost of your gas is related to the rand-dollar exchange rate, just doesn't make sense.
Yeah,
Can I just?
When you deal, sorry, and now suddenly you find that it is doing the damage that they overlooked into the environment and the economy, and you try and get out of it. So again, we just want to know how do they arrive at that decision. Our modeling says it's wrong, it's bad, but we need to get the information to be very sure about it.
Can I just comment?
Sorry.
Can I comment on your answers, if I may? Most of you will know that I was not specifically against the car power ships. I was against the terms of the RFP. And I just would like to use this opportunity to reiterate that the terms were so bad that all of the projects that were mainly renewable could have come in at half the price they did if you changed 3 simple rules in the RFP. So we had a whole lot of clever people all over the world finding a solution to a badly crafted problem. And I just want to let people know that if you just tweaked 2 or 3 rules, we could have been paying 8 billion a year for 2,000 megawatts instead of 16 billion. Whether or not, and in fact, the car powers wouldn't have had a look in that because they wouldn't have been able to compete with the price. The price, it's possible to do what the risk mitigation called for at less than R1 a kilowatt hour if you just allow system integration with the projects. And so the licenses that NERSA issued, in my opinion, none of them should have been issued until the terms had been changed to save the South African taxpayer 8 billion rand a year on what those contract prices would cost. And I've made this at the NERSA hearings. I wrote a briefing note on this, and it's just shocking. And unfortunately, the attention was cast on car power ship, whereas the attention should have focused on the RFP put out by the IPP office that was not fit for purpose. So thanks for allowing me to just get that off my chest for the 400th time. Thank you.
Well done, Clyde. And I think our advisors have given us a lot of that type of input, the modeling experts, to say exactly that. And again, as Bonnie said in our statement, this is a self-made problem we're in right now. And at the time of that, of those requests for input, had exactly what you said transpired, there would have been a lot less need for load shedding right now, because a year and a bit has passed and so much more could have been done. But thanks for that. Okay, another question. No more questions in the text box. I think if there are no more questions from the people in the Zoom room, then we will call this media conference to a close. I want to thank you for attending. I don't see any more hands up. And as I said, on OUTA's website, outa.co.za, you will find more detail, the statement itself, as well as the affidavit that we filed today. Thank you for your time.